and welcome to this webinar about family investment companies and family trusts, being co-hosted by LCF Law and PD Tax Consultants. Next slide. Yeah, that's a picture of me. For those who don't know me, Paul Davison. I'm the founder and director of PD Tax. And on the next slide, it tells you a bit about what we do. So we are tax specialists. We don't do accountancy, general accountancy, which gives us a lot of referrals from accountants. And the types of things we do are listed there, which include tax advice is probably the staple of our work. We provide tax advice for business owners, entrepreneurs, individuals, trusts and estates, charities. Provide a lot of advice to professional advisors and their clients, accountants, solicitors, financial advisors, when their clients get into either tax issues or have opportunities to save tax. We also provide like a tax partner firm for accounting services where they can just call us up or chat to us about issues and bounce things off us, which is a useful source of knowledge for them. We do tax return forms, but they tend to be more complicated ones where there's issues with disclosure or tricky technical issues. Share valuations for private limited companies for divorce or tax or disputes or whatever. And we also get stuck into tax investigations and voluntary disclosures. Can't be a good tax investigation.
Thanks, Paul. I'm Anne Christian. If you were expecting to see Haroon, I'm sorry, he's unavailable to be here today, and you've got me instead. I'm a partner in our personal law team, and I help my clients plan for the future, a lot of the time involving setting up trusts for them or advising on trusts they have. We're also joined this morning, next slide please, Devon, by Cathy Cook, who's one of our corporate team, and she'll be talking about the company angles of the options available. LCF Law is a long-standing legal firm based in Yorkshire. We're an integral part of the legal, business and financial community here. There are 125 of us across our offices in Harrogate, Ilkley, Bradford and Leeds, and our aim is to be the best law firm in Yorkshire to work with. Law can be complicated and confusing, with no doubt about it, but we try to make the legal advice simple and easy to understand. We help our clients solve their problems. What we're going to talk about this morning is, firstly, what is a family investment company and what is a family trust? We're going to look at the tax benefits of both alternatives. We're going to talk about the legal obligations that come with them. We've then got a couple of scenarios where we talk about how the different options might suit certain clients. And if you've got any questions at all, please pop them in the chat as we go along, or if you prefer, contact any of us afterwards and we'll be happy to talk through whatever questions you have. So firstly, looking at what is a family trust. There's often a misconception that a trust is set up for tax planning purposes. They can certainly have a role in tax planning, but there are many other uses for trusts. Trusts first became a thing in English law back in the time of the Crusades, when you had all these landed knights or soldiers going off for years, and they wanted to make sure that their families back home could receive the benefit from their lands, but those lands would be managed in their absence. So trusts were the vehicle to do that. Now we do an awful lot of trusts for couples, say, who are on a second marriage. So they've each got children from a previous relationship, and they either live in a house that's owned by one of the couple, or they bought a property jointly, and they want to make sure that their house or part of the house goes to their own children in due course, but the other person can live in that property whilst they're alive. Again, a trust is the answer there, with no tax implications. So when we're talking about setting a trust up, we've got to make sure that there's a split between the legal owner, so that's the person in whose name the assets are, and the beneficiary, so the person who maybe has the right to live in the property, receive dividends or whatever. Generally speaking, trusts are less tax efficient than companies. Paul and Cathy will come on to talk about those differences shortly. In the scenario I'm going to look at a little bit later, we've got John and Mary, who are the couple who've built the wealth up and are now looking for advice about how to structure things going forward. So in that situation, John and Mary will be the settlors. It's important to appreciate that if they go for a trust, they can't be the beneficiaries of that trust. Otherwise, for tax purposes, it just doesn't work. So John and Mary would establish the trust and set out the rules that will apply to it, such as who the beneficiaries are, how long the trust will run for, what powers the trustees have, and if there's anything else that needs to be considered. John and Mary then put the assets into the trust. It then turns to the trustees to manage and distribute the assets from the trust fund to the beneficiaries in line with the terms of the trust. So John and Mary as settlors can be trustees. They don't have to be the only trustees, and if they're looking to the future, they might want to put some other younger trustees on as well, for example, their children. But it is the trustees who will make the decisions going forward. One major advantage of a trust is that it's very flexible. So if, say, one of their children is perhaps looking at getting divorced, a trust would be a way to protect the assets there. It might also be the case that, say, one of the children has not yet shown themselves as capable of managing large sums of money. So again, a trust might be a very useful vehicle from the point of view of flexibility. Come with the next slide, please, Devon. Thank you. The family investment company is an alternative way to pass wealth between the generations. And when you've got a company, the shareholders and the directors can be family members. It's generally less flexible than a trust, but it can be more tax efficient. So in our John and Mary situation, John and Mary can potentially receive both income and capital from the FIC, as we call it. When we're looking at what is the difference between a FIC and a more regular company, there's no magic that needs to be applied to make a company a FIC. It is just that in general terms, FICs tend to be investment vehicles, and often they have different share classes for different generations. This is to allow younger family members to benefit financially, but for John and Mary perhaps to retain the control that they want. And to start the FIC, the personal wealth would be introduced by John and Mary by way of a loan, and Paul will come on to that in a moment. I've been talking about FICs and trusts as different entities, and it's really important to appreciate that you have one or the other. You can't take the bits that you want and make a structure that perfectly suits you. But what you can have, and what a lot of clients have, is both. So that is a fairly common scenario where you've got the suitability of a FIC, but particularly if, say, you've got children or grandchildren who aren't either old enough or mature enough, or for whatever reason not suitable to receive assets outright, you can have a trust that owns some of the shares. We'll now turn over to Paul to talk in more detail about those.
Thanks, thanks, Anya. I'm just going to talk for a few minutes now about sort of the tax aspects of a trust compared to a family investment company. And the logical first thing to look at is how to get money into one of these two vehicles, either of these two vehicles. With a trust, you tend to do like a gift, a distribution into the trust, so it falls outside of your own estate after a certain number of years. And the highlight there is that you can, in terms of avoiding tax and putting money into a trust, you can only transfer really a gift of up to £325,000 worth of assets into the trust and avoid tax. Anything above that is going to attract tax, inheritance tax at 20%. So a husband and wife can put in £650,000 into a trust tax-free in any 7-year period. A family investment company, like I mentioned, you would tend to put the money in via a loan, although you can do it via subscription of shares. But a loan would tend to be the best way to do it, because if you lend the money in, then you can get that money back out tax-free in the future. So you can, so the funder, the founder of the FIC can lend the money and get the money out as and when they see fit. But with the family investment company, there's no tax on contribution the money in at this initial stage. So the FIC's a bit more flexible there in terms of how we get the money in. Next slide, please, Devon. And then we're looking at sort of the normal ongoing affairs of the two vehicles and how the trust rates compare. Well, with the trust, we've got the highest rate of tax, 45% on its general income. It does pay the highest rate of tax on dividend income as well, 39.35, and capital gains tax are payable at 20%. With a FIC, your general income is charged at the corporation tax rate, which is now 25%. So that's a big advantage above a trust, which is 45%. Another large advantage is that no corporation tax is payable on dividends received by the FIC, because it's like a dividend from a corporate to a corporate. So that's a tax neutral type of transaction, no tax there. Could be some withholding taxes if it's a foreign dividend. Capital gains tax slightly higher at 25%, unless you own unless it owns shares in the trading company. So what we're saying there is that, generally speaking, it's going to be better to have the funds rolling up in a FIC rather than a trust, because there's a lower tax rate in general. Next slide, please. Next slide, please, Don. Tax on unrealized capital growth. It's an interesting one. With a family trust, we do have an actual tax on unrealized capital growth. So value of the shares or value of anything that's not been realized, if it's shares, property, you do have the 10-year charge, effectively, which is a 6% charge every 10 years on the sort of the value of the trust at that 10-year anniversary, and everything needs to be revalued. Even if you've not realized the assets, it's got to be revalued. We're paying roughly 6%, give or take the sort of nil rate band. Whereas shares in the FIC, there's no tax. There's no ongoing tax on the value of those shares. You just hold them normally, and if you sell the shares, there's tax, but ongoing, there's no tax there. So we know that family trusts, people can be put off by the fact that you've got to pay this 10-year charge because it's effectively unrealized, and where do you get that money from? Next slide, please, Devon. The main advantage, though, like Em mentioned, is the fact that trusts are sort of more advantageous in terms of flexibility, and this is the major benefit for a trust over a FIC, in that you can set up almost whoever as a beneficiary. So as an example there, as new family members are born, grandchildren, etc. are born, they can automatically become part of a class of beneficiaries, and they can benefit from that trust. Whereas the differential with a FIC is much more specific. An individual has to own shares in that trust to provide benefits to that person, to provide rights. You can't be within a class and just be generally subject to something in the future. You've got to have rights over a share to benefit. And that's really where we sort of move on to sort of talk now a bit about how we can manage that for a FIC, how we can manage the sort of the succession planning that trust provides. Obviously, the FIC provides really good tax breaks and tax advantages, but it's more restrictive in terms of how we manage succession. So we're on to next slide, please, Devon. We'll talk about how we do that. So one of the first things, which is actually a bit of a sundry thing with FICS, actually, is that actually you do get, because if you own a minority in a family investment company, by definition, the sum of the parts is not always the whole. Looking that up anyway. What I mean there is that there's a discount for minority. So if you own a 10% shareholder, if an individual family member owns a 10% shareholding in a company worth £1 million, on the face of it, that shareholding should be worth £100,000, because the family wealth is £1 million, and they've got 10%. You should own 100,000. But actually, because of the rules around minority shareholdings and discounts to do with this, we are able to apply a discount for minorities. So what I've said there is that illustratively, a 10% shareholding might only be worth £80,000. So by definition, straight away, you've shaved off £20,000 of value when it comes to looking at the IHT bill for the family as a whole. So that's a little bit of a bonus for FICS, that you do get this discount for IHT, which just starts to shave money off the IHT bill. And we all know that IHT is not a tax we can just smash with a hammer. We've got to sort of keep chipping it away at it to try and reduce it and keep planning away at it. Right, have a next slide, please. So yeah, so this is where we come to sort of the meat of the issues with the FIC and how we start to plan about succession. So if we set up a new company as an investment company for the family, this slide really shows you how you might look to set up that shareholding. The founder of the vehicle, the FIC, is going to want to retain control. That's definite for the situation. So they're going to want to retain at least 75% of the shares, because that gives them ultimate control of the business, allows them to liquidate, etc. But the founder might not want a dividend, because they might have the loan that they've already put in, so they might be able to draw down that loan tax-free. They might be able to get interest on that loan. They might get a wage from managing the FIC. They also might have other income which they can rely on throughout their sort of retirement stage. So they might not want shares that provide them with dividends. And the founders, might not even want right to capital, i.e. if it's liquidated or sold to somebody else. Because what they tend to see is this fund as being like their legacy. So they're providing this legacy to the more junior family members, and therefore they do not need capital rights over that. It's their legacy. They're wanting to push that down the tree to their grandchildren, etc. So the founders don't want rights to capital. So all they've got really is rights to vote. If we're starting from scratch, they've probably just got rights to vote, and they might want some rights to dividend, who knows, but often it's just the right to capital. Whereas the children are going to get a right to income when they probably get to 18, when they become adults, and they're going to get the capital rights. When it comes to looking at children, if they're obviously adults, that's fine. Minor children below the age of 18 can be given shares, but we need to set up some sort of bear trust for them to earn those shares through. And they can have rights to capital and rights to dividends as could adult children. Next slide, please, Devon. So that all seemed quite simple, but the problems come really when we have a company that's already established. We've got an investment company owned by the family, owned by mum and dad, say it's got property in there already, it's got significant capital value. But they want to start to think about how we can move value down the line. The problem with this is that if we move shares directly to the children, we've got to pay capital gains tax. One of the key things that I think is important with inheritance tax planning is that you shouldn't really pay capital gains tax in trying to mitigate IHT. Sometimes you can if you're desperate, but one of my principles is don't pay CGT if you're trying to plan for IHT. The reason for that is that if you do pay the CGT, i.e. 20%, on passing stuff down to children, you could end up with a 60% tax rate if you die within 7 years of making that gift. Because you've paid CGT on gifting it, then you've got to pay IHT if you die within 7 years of making the gift. So you could end up with a 6% tax bracket, which is not what you want. So one of the solutions really, which is becoming more common, is this sort of freezer growth solution, where we've got capital value of existing shares. And what I'm going to do here is we're going to say, right, what is the current value of the company? And whatever that value is, that's going to be sort of the hurdle price. And we're going to freeze the founders with the capital value in our estate. And we're going to set up growth shares for the children with a right to capital above the current value threshold. And what that does is, as equity starts building up in the company, it starts to move to the children rather than the existing founders. So we're drawing a line in the sand. The founders are keeping the existing value, and the children are getting the future value. So that's good. It's freezing it up. And then what we can do after that is then we can start thinking about, well, we've got this block of freezer shares. What can we do with that? We can then start to think about whether we could reduce that by dividends paid on the freezer shares in the future, and does that reduce the capital value? We can also think about whether we can actually put some of those shares through a trust to move to because we can move shares into a trust up to £650,000 every 7 years to avoid CGT, and then move those shares by a trust down to the children. So it's not a perfect solution, but it's a way of sort of starting to move value down the tree. And if we do it sooner rather than later, we can get that capital growth hurdle as low as possible and get value down to the children. Next slide, please, Devon. So, in conclusion, tax rates on investments are materially lower in a FIC than a trust. So money's going to roll up quicker in a FIC. But trusts are more flexible than a FIC. So this makes planning, IHT planning around a FIC more important and something that we've got to consider at least every 7 years and as soon as possible, really, because if we leave it too late, it becomes more and more difficult to try to eat into that capital value and save IHT. Thank you.
So if you're looking at setting up a FIC, one of the first decisions you've got to make is whether or not you want to set it up as a limited or an unlimited company. And the advantage of, to do a limited company, you have got to comply with your filing requirements and the regulatory regime. So you are required to submit accounts on an annual basis to Companies House. You do also have limited liability in the event that any of your investments are slightly potentially loss-making. You won't be found responsible for the debts involved. If you're going to go down the unlimited company, it can be very attractive that actually you're not filing accounts. There is that exemption in there, so people don't necessarily know what your family is worth. But then you have got to also take on the chin that you could be potentially personally liable in the event that there's a problem with the company. Next slide, please, Devon. So when setting up the family investment company, you are thinking about who you want to benefit. Are you looking to benefit your direct descendants, your children, or would you also like the flexibility to add future grandchildren into it? And you need to take advice about the share structure, who's going to have the rights to capital, will you have different dividend rights, where do the voting rights sit, how can the shares be transferred, can the directors of the company basically block transfers out to individuals that they're not happy with for whatever reason, and also just checking that the trustees of the trust have got the appropriate qualifications, etc. And so if the trust is set up as a shareholder or shares are put into a family trust, who's actually going to be controlling that family trust? Again, thinking about how the FIC is to be financed, sometimes you'll find that actually it's ultimately just ordinary companies, and there may already be a company that the parents have been running for some years. It may have some property in there, it may have some personal investment products in there. So it's already in existence, basically. If the family investment company has been set up from scratch, you then have a decision as to whether or not they subscribe for shares at a premium, or whether it's put in by way of a loan. And of course, there is the advantage of a loan in that actually, depending on how much goes in by way of loan, that loan can be repaid over a period of years with no adverse consequences. And again, thinking about how the profits will be extracted, looking again at dividends. If you can declare dividends on different classes of shares, then you've got the flexibility to, help one child with the purchase of a new home, help with university fees for another one. If you're repaying the loans, that will give mum and dad potentially a right to income for the next few years while that loan is being repaid. Again, you're looking at any built-in IHT planning, and this is whether or not you've got a trust as a shareholder, and whether or not that the monies have gone in by way of the annual exemptions there and the 325,000. And you're also thinking about lifetime gifts, and you're looking at your anticipated annual professional costs, because if you're going to be filing accounts on an annual basis, you're going to need an accountant. So yeah, it's whether or not, again, it's going to be a limited or unlimited company, as we've just discussed. So now going across to Anne with a scenario for you.
Thank you. Pardon me. Thank you, Cathy. So in this scenario, we're talking about John and Mary, who, as I mentioned before, have built up a considerable amount of wealth through hard work. They're now in their 60s and they're looking to what the future and what they can do to plan. They've got 2 children and 6 minor grandchildren. John and Mary want to treat their family members fairly and equally, but, and it's a big but, they have terms, and they're not comfortable with the idea of their children having a massive amount of money too early, because they don't think that will be good for them. They want them to learn to manage the money properly. John and Mary are also concerned about their inheritance tax liability. They're not comfortable with the idea of making substantial gifts outright to their children, partly because of the control issue, but also because they're concerned that their son's marriage is rather precarious, and if he were to get divorced shortly after receiving a large amount of money, fair chance that the soon-to-be ex-wife would get a considerable amount of that. They also just have concerns about control generally, in terms of wanting to make sure that the children are sensible with money. Excuse me. John and Mary have worked very hard and built up this wealth, and they have an expensive lifestyle. So they want to make sure that they're not constraining themselves with what they do with this money in the future. They do want to have access to at least some of it if needed. So we're going to have a quick look through what a FIC could do in this situation and what else they could consider. Devon, next slide, please. So we've talked about a FIC and the tax advantages that it offers. For John and Mary, control is essential, and with a FIC, they can certainly still have that control. As Paul's explained, it's possible for it to be set up in such a way that the growth in value is outside of their estate, which would be useful for inheritance tax purposes. John and Mary want to still have access to some degree to the money, so having loan repayments from the FIC would be a very useful way for them to do that. As I mentioned when I was explaining the difference between FICs and family trusts, often in a situation it's advantageous to actually have both. So in this sort of situation, John and Mary might want to set up a trust, or possibly more than one trust, for the benefit of their grandchildren, and those trusts would then have some of the shares. The income would then be paid out to those trusts, and that could be then used to support, say, the grandchildren's education or whatever else is needed. The children, or indeed the grandchildren, can become directors once they've reached the age of 18, if that is what is suitable and wished for by this family. And as Paul mentioned, for an inheritance tax perspective, John and Mary can start making lifetime transfers of value to start that 7-year clock ticking and remove the assets from their estate for inheritance tax purposes. Next slide, please, Devon. Disadvantages of a FIC do need to be considered, though. It isn't as flexible as having a trust, and there's also all of the compliance requirements. Of course, there's going to be compliance with a trust as well. So I'm not saying for 1 minute have a trust and don't have any compliance issues, but there are going to be more compliance issues if you have a FIC. There's also the sort of future proofing, if you like. If, for example, John and Mary get more grandchildren or possibly great grandchildren that they want to benefit, if they're to have just shares in a FIC, they would need to have new shares issued at an appropriate time. Whereas if they'd gone down the trust route, you can define the beneficiaries of that trust as our descendants, and then you don't need to specifically add future grandchildren. Next slide, please, Devon. We also do need to just touch upon business relief for inheritance tax. Business relief is quite a complex area in itself, and I'm not going to go into that this morning, but it is important to point out that generally it's not going to be available on shares held in a FIC structure. To get business relief, it would be needed to show that the FICS activities constitute a business and the business does not consist of basically holding or making investments. Paraphrasing, it's got to be a trading company. And there are other criteria as well to be met, such as how long you've owned the shares in the company, but it's going to be very difficult to tick all of those boxes if you've got a fixed structure. So in the scenario of John and Mary, as we've talked about, it's probably going to be suitable for them to have a FIC set up with on the side a trust or possibly more than one trust for their grandchildren or potentially other family members. I'll now hand over to Cathy to look at another scenario.
Thank you. So in my scenario, we've got husband and wife, Paul and Sally. They've got 100 shares between them in equal shares, so 50 each in a private limited company. And the private limited company has a property and investment portfolio with a value of approximately 1.5 million. They've been working on it for quite some time. They've got 3 children who are all adults. They've got Tom, who's 27. He's engaged, he's living with his fiancée, and is planning to get married in about a year. They've got Lucy, who's 25 and is somewhere in South America. The credit card bills are increasing and she's showing no signs of coming home at any time in the near future. And then they've got Sam, who's 21, lives with mum and dad, and he lacks capacity to make decisions. It's unlikely that he's ever going to be able to live independently. Next slide, please. So their objective is that they want all future capital growth to accrue to the children in their company. They want to be able to benefit from annual dividend payments, but they'd also like to be able to pay dividends to the children at their discretion. And they obviously want to retain voting control. They're not yet prepared to trust any of their 3 children. They also want to make sure that the transfers of the shares are restricted between family members going forwards. Next slide, please. So the risks that they can anticipate are a potential relationship breakdown if Tom's relationship doesn't work out, or Lucy meets somebody while she's traveling. What will happen in that situation? What about bankruptcy? Lucy is potentially financially vulnerable. She seems to be getting lots of letters from debt collection agencies and showing no signs of getting a job and paying off her own debts. And then they've also got Sam, who they know is never going to be financially independent and is also always going to need looking after, and what will happen to him if they're not around to be able to look after him. They don't want the children to have shares in the company if there's a possibility that they could lose those shares through bankruptcy or divorce. So what can we do? Let's look at the solutions. Next slide, please. So of the 100 shares, Paul and Lucy are going to redesignate those shares into 5 different classes. They're going to have 35 A shares and 35 B shares, 10 C, 10 D and 10 E shares. Paul will have the A shares, Sally will have the B shares, and then they will give C shares to Tom, D to Lucy, and E shares will go into a trust. with the intention of which will be that Sam will be the main beneficiary, but that there will be flexibility within that trust to be able to benefit other descendants of the family. They'll adopt new articles of association which sets out the following rights attaching to the shares. Each class of share ranks separately for dividends, so that they can determine that if they want to help Tom, for example, with his wedding or his first home, they can pay a dividend on his shares to give him an income in that particular year. The A and the B shares rank in priority on a return of capital or exit ahead of the other classes of shares up to the threshold, being the 1.5 million value of the portfolio of the company at the moment. Once the amount to the value of the threshold has been distributed, they have no further capital rights. They could decide that they want to participate in future capital growth, but with other investments, etc., that they have, they don't think that's necessary. So once that threshold has been distributed, any balance above that level will be distributed between the holders of the C, D, and E shares as though they were one class of shares. Only the A and the B shares have any rights to vote, and transfer rights are permitted between family members, permitted between trustees of a family trust, and otherwise are subject to the absolute discretion of the board. There are deemed transfer provisions in the event of bankruptcy, which would basically mean that should one of the shareholders be declared bankrupt immediately prior to that bankruptcy event, there would be a deemed transfer back to either the company or to the other shareholders. And in the event of a family member ceasing to be a family member, so for example, in the event of divorce. Next slide, please. So really the message of this seminar is that if you've got a family in this kind of position, they do need to think in advance and plan carefully. So they can make lifetime transfers for IT, CGT, and connected party disposals, transactions in securities, so when employee-related securities do need to be looked at. The dividends can only be paid if there are sufficient reserves in the company, distributable reserves. So if the company is not making profit, they cannot pay dividends if that's going to be something they're going to be relying upon. There are going to be filing requirements and administrative costs, both in terms of tax returns and also accountancy costs if it's a limited company. And you also need to bear in mind corporation tax rates, which we all know can be subject to change. Next slide. So the decision depends upon the situation. As we've said, there can be a combination of the two solutions. You do need to look at the priorities of the family and their individual circumstances, and tailored advice is really recommended in each case. We're very, very happy to help. And now if we've got any questions, we can move on to see if we've had any questions.
So we'll just give it a couple of minutes. Thank you both. Thank you everybody. Just wait for a couple of questions to come through.
Okay, so we've got one question which I think is for me, or possibly also Paul. When would the freezer growth shares be practical? And really that's where you're using an existing family investment company, which there's already a value in there. And you want to you don't want to actually make it, if you were to gift those shares originally held with capital rights, it would count towards it would be a lifetime gift. It would start the clock ticking for the 7-year period, whereas if you create freezer or growth shares, there's no value in those shares at the point at which they are created, and therefore there's no tax liability at that point. Does that sound about right, Paul?
Yeah, yeah. I think what we're trying to do is we're trying to avoid capital gains tax, because if we gift existing shares of value, we're facing a 20% CGT bill, which we don't want. So, but you're right, Cathy. We're setting it up if we've got existing value, and because we don't want to physically pass that value down. We just want the children to benefit from growth effectively. And I think there's a thought these days actually that the growth shares aren't worth nothing because they are right for the future. Clearly, we've already counted for the current value in the hurdle. But I think that the current thinking is actually those shares do have some value because they've got an uplift potential. So we're doing the most recent jobs we've been doing. We've done like a sort of a black skulls type of valuation on the right for growth, and it tends to come out with about sort of £3,000, £5,000 worth of costs that the children have to fork out for these shares. But we can do that via some sort of loan arrangement or whatever. I think the HMRC have been quite keen on saying that actually these shares aren't worth nothing. They have got some value. So as long as you spend some time thinking about that and come with a value, then that should appease them if HMRC ever come knocking, is our current thinking.
Yes, thank you, Paul. We've also got another one which says, presumably if the trust needs registering on the trust register.
I think that's for me, probably. Yes, the trust will need to be registered on the trust register. As and when there's income or gains arising, obviously that will need to be reported to HMRC as well.
Cheers.
Thank you, Devin.
And then we've also got another one. This one says, how do you get shares back in the event of a relationship breakdown?
I think that one's from me. So that's the articles would basically say that there'll be a deemed transfer provision, a deemed transfer notice. So the recipient of those shares. So the scenario where this would occur would be, for example, in my scenario, Tom gets married and he decides to give 5 of his C shares to his spouse so that she can benefit from any dividends that are declared on those C shares. Obviously, the transfers between spouses are exempt for capital gains tax, so he can do that without any implications. The relationship breaks down 5 years' time, and immediately prior to that divorce, she is deemed to transfer those shares back, and you can actually restrict the value at which she has to transfer those shares back. So it's dealt with through the articles effectively.
Cheers, thank you, Cathy. And we've got another one which says, is it possible to include shareholders, is it possible to include a shareholder being served with a divorce proceedings as an event which triggers a compulsory transfer back to the majority shareholder and or the company in the company's articles?
I would say so. I think you can probably put in there yourself which trigger events you'd like to include effectively. I mean, you can always make up. It's not terminal until the actual divorce is granted, is it really? So you may not want to do that, but yeah, I think that's entirely doable.
Yep. Cheers, thank you. And then we've got another one which says, are there any consequences of adding a family investment company to the class of beneficiaries of a discretionary trust? Is that one for Anne?
Yes, probably. I can't think of any tax consequences, but also it would be an unusual thing to do. So I suppose what we'd need to look at is what actually we're trying to do by adding the company as a beneficiary of the trust, and then we look at it. Paul, have you ever come across that in practice?
Is it not? Well, is it not a question of? Is it not the case of having them as the trust as a shareholder? Am I getting that wrong?
Yeah, this is the other way around.
Is it the other way around?
Do you want to reread it? So it says,
reread it, yeah.
Sorry, it says, are there any tax consequences of adding a family investment company to a class of beneficiaries of a discretionary trust?
So the brain's gone numb.
So should we answer the next question and then come back to that one?
Yeah.
So yeah, it's just not something I've ever come across in practice.
I can't see why it would work from a commercial point of view. I can't see what the point of it would be, really.
I
think the short answer is there's no tax consequences of just adding them as a potential beneficiary, which is what the question's asking.
Yeah.
There are no tax consequences of adding anybody as a potential beneficiary. would just need to and maybe think about what you were trying to achieve.
Yeah, I suppose you have to think about what if you're right. So what happens if they do? But what if the FIC does benefit? Suppose you're right, and if they're added as a potential beneficiary, that's fine. But then, if they do receive anything, what are they going to receive? I suppose it would be taxed as normal, wouldn't it? Be taxed as if it was a dividend, it'd be taxed as a dividend would be received in the company. If it was a income, they'd be taxed as if it was income received. I think I'm just not quite sure how you're going to get. Yeah, that's right. I don't really know why you do it, but that's why it's a bit difficult to answer the question.
And then the next question, cheers, thank you, Paul and Anne. Next question is, when would you consider a family trust owning all the shares in a FIC?
Shall I have a go at that one, or
Go on then, Paul.
Yeah.
I think we have talked on this. Talked about this briefly. I think I mentioned it here a bit about actually maybe not having all the shares owned by a trust, but having some of them, because there are some advantages of it. Like one of the advantages would be the school planning, the school fees planning that I mentioned, whereby if the dividend is paid up to the trust to then use by the trust to pay school fees, we get the advantage of using the children's personal allowances to effectively make it a tax-free way of getting money out of the company. So that's good. That's a good thing. And I don't know, I was thinking about this beforehand. I think the reason you might use it is obviously that if you want a FIC, we've talked about a FIC being a great place to have the money roll up, but more difficult in terms of succession. And I think you might end up with a trust earning some of those shares in a FIC. You've got quite a broad, widespread family, or quite a broad sort of potential pool of beneficiaries. Because if you do that, you sort of say, well, actually, it's just too difficult to keep bringing them in as shareholders. It's so wide that we're just going to have to take some of the tax hit of having a 10-year charge, and then utilize it as best we can. So I think you've got quite a broad range of beneficiaries. You probably might use a trust to own some of the shares or all the shares. You've got quite a sort of a nuclear family that's got like two parents, 2 children, 4 grandchildren, etc. That maybe you don't need this trust arrangement, because it's easier to sort of denote them as individual shareholders, because we've got a tighter group of people. Was something I was thinking of. Any thoughts from you two?
Yeah, I mean, it would really be a situation where, the settlers, the mum and dad, potentially actually aren't ever going to need to benefit from the assets in this family investment company. So they would be potentially quite happy to make sure that it's all going for the benefit of future generations, and maybe they're a little bit worried about the immediate future generations, and don't necessarily trust any of them being in a position to benefit from the shares going forward. So I think it would be about control, really.
Yeah, and as long as mum and dad aren't going to need anything back.
Yeah.
Cheers. I think that's all the questions for today. Cheers, thank you all of you. Hope you enjoyed it. And thank you everybody for joining. I don't know if anyone's got any last words before we end.
Thank you for coming along. I think we are going to distribute the recording. Is that right, Devon?
Yeah, so after this, we'll forward it off on the recording across to everybody, and we'll also share Paul and Cathy's details amongst everyone as well. So thank you for joining, and we'll be in touch.
Great.
Thank
you.
Bye.
Bye.